Good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar where we're going to be discussing laws that protect information. Hopefully, I think we have all the bugs worked out of our new system and things will go without any hiccups this morning. Apologize for the previous sessions. We're still based on Teams, okay, so we're familiar with that, but here we have a new system where there's a package called ClickShare that is kind of overlaying Teams. And it turned out that there were some Wi-Fi issues in our building that the workaround is that I'm hooked into a cable because of the Wi-Fi. Apparently, it just can't be improved at all. But things seem to be working. So hopefully we'll be able to get through this without any hiccups, like I said. Okay, a couple preliminaries as we're getting started here. First, this session is PowerPoint based with me talking in the background. The PowerPoints are available on the Office of Open Record website. You would go over to the training tab, scroll down, you'll find this PowerPoint, as well as all the others that we use for training here in the office. With the various topics that we have. Feel free to, access this PowerPoint as well as any of the others. They're there for you to use. It may be that you have a friend or colleague who couldn't make it here this morning, so they can go back and look at the PowerPoints to kind of see what we're talking about. It's possible that you're conducting or you're planning to conduct some local training for staff, and the PowerPoints, if they prove helpful, that's great. Like I said, feel free to use them as you deem necessary. Also, this session is being recorded. Hopefully, I think I hit the right buttons. And the recording in a couple days will get uploaded to our YouTube channel, and from there, a link will go to the website. Again, go over to the training tab, scroll down, and you'll find all of the recent videos for training sessions that we've done here with the webinars. There may also be a couple others in there about recent trainings or conferences that we've done. Same conditions apply. You can use those to refer to for your own benefit in the future. Again, maybe you have a colleague who couldn't make it this morning, so the recordings will be available. And if it's possible that you want to conduct some local training and just have people watch the video of the webinar, that may work out for you too. Okay, so now let's talk about questions. You can use the chat feature to type in your questions. That's the one thing that I'm not crazy about this new system. It seems like we took a step back, but that's me. Okay, so type in your questions in the chat feature. I will do my best to answer them live as we're going through the presentation. Number one, we're talking about laws that protect information. So let's stay on topic, okay? We want to be talking about that. Second, it's really helpful if you can keep your questions as short as possible, direct, succinct, whatever, okay? Occasionally, folks will type in several paragraphs, and it's just awkward for me to sit here and read through it while everyone else is waiting patiently. Look, if you have something that's unusually complex or that is unique to your situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll try to scroll back and address your question there for the good of everybody who's able to stay on. Or I would suggest that we take the conversation offline, meaning you reach out to the office. The contact information for the office is on the screen now. Whether you email or call in, first you'll be in touch with one of our admin staff who are fairly well versed on the right to know law, and they can usually get you headed in the right direction. If you happen to stump them, we'll take your question and escalate it to one of the senior staff. And they're very good about getting back to you, usually within 24 hours, because we realize if you're reaching out to our office, number one, it's probably something pretty important. Number two, it's probably time sensitive because of all the deadlines that are built into the right to know law. So, like I said, we're pretty good about getting back to you quickly. Feel free, whatever the situation, to reach out to the office and we'll try and help you out. Now, just for the good of the order, we can't write to know requests for you. We can't answer right to know requests for you. And we can't discuss any active appeals that your agency might be have currently before one of the appeals officers in the Office of Open Records. Okay, it all makes sense, and hopefully, you're able to get whatever you need from us to move forward. Okay, so let's talk about laws that protect information, and I want to begin by talking about why this is important. Okay, if you're familiar with the right to know law, you realize that within the right to know law, there's Section 306, which I'll paraphrase here, but nothing in this act shall supersede or modify the public or non-public nature of a record or document established by federal or state law, regulation, judicial order, or decree. Okay, let's translate that to English. It basically means that if there is another law that says a record is confidential or private or secret in any way, that law supersedes or trumps the right to know law. The right to know law is not a confidentiality law. If you sat through the basics course, you know what I'm talking about. The right to know law gives the agency the discretion to release a record, even if it falls under one of the exemptions within the right to know law. You can have a record that is clearly defined by one of the exemptions. And an exemption is, there's a section 708 in the right to know law that lists 30 exemptions. These are definitions of records that the agency can withhold at its discretion. Okay, so the agency can decide, even though this is clearly covered by this exemption, we're going to release it anyway. Okay, and they, it depends on the circumstances. They may have a very good reason for doing so. But what we're saying here is that if there is another law that says this record is confidential, and I'll give you an example here as we get into the presentation. I'll give you a couple of examples, as a matter of fact. Then if there is another law that says this record is confidential, that removes the discretion that the agency would otherwise have in most cases, because these other laws usually don't allow for the release of the identified record. And if by chance the agency would release it unknowingly, there very well could be sanctions taken against the agency for doing so. They would be violating that other law and the privacy provisions within it. Okay, so it's important, especially on the agency side, that we be aware not only of the exemptions within the right to know law, but also these other laws that are out there that protect information. Now, what we're going to cover today really are the top 14, if you will. These are the laws that, looking at our appeals, that our appeals officers most often run into. So that's why the presentation is a little disjointed. It doesn't flow as smoothly as the others normally do, if you think we do that, because we jump around. We're jumping around from one law to another. Some of them are related, others are completely out of the blue, but they are the most common laws that we face here at the Office of Open Records that we will refer to, or that are raised by agencies when they're defending their positions during the appeal process. The second reason that this is important, and again, this goes back to being familiar with the right to know law, is the fact that the agency is responsible for bearing the burden of proof. Okay. Prior to the Right to Know law, we had what was called the Right to Know Act, which, its genesis went back in, I think, into the 1950s. Under that act, if the agency denied access to a citizen's request for a record, the citizen had to take the agency to court and sue in order to get access to that record. And they had to explain why they believed it was a public record and why it should be released. With the Right to Know law in 2000, written in 2009, made effective 2010, it changed 180 degrees. Now it's the agency that bears the burden of proving why a record is not public. Okay, so they have section 708, and in A1 it explains the burden of proof, which we talk about during the basics webinar. But then we go to section 708B, which lists those 30 exemptions. Okay, and that's what I was previously talking about. Okay, so let's say you've got a record that isn't necessarily, that doesn't necessarily fit into the definition of any exemption. But there is another law out there that says this record is confidential. The agency can then refer to the confidentiality provisions of that other law and use that as the legal basis for meeting its burden of proof to show that this record is in fact confidential and we cannot release it into the public domain because that would otherwise be a violation. And that's really what we're going to talk about here this morning, those other laws that protect information, that in a general sense, any agency open records officer or Right to Know officer, same thing, should be at least, should have a cursory familiarity with. Okay. You don't have to have the laws memorized, but you should be aware that there are these other laws out there. And, we are in no way covering all the laws, but we're picking out the ones that we encounter here the most. Okay, so that kind of sets the stage as to why we need to be familiar with these other laws and have this discussion. The first one I want to talk about is probably the one that we most often run up against, and this deals with law enforcement agencies. The law is called the Criminal History Records Information Act of 1980, commonly referred to as CRIA. Okay, now CRIA is a law that essentially identifies most of the records that the law enforcement community comes in contact with, distributes among themselves, and it establishes levels of privacy and confidentiality for these records, most of which cannot be shared outside of the law enforcement community. Okay, so when we talk about a law enforcement agency, and let me get off track a little bit again here. It's always important to familiarize yourselves with the definitions section of a law when you're attempting to understand it. And CRIA is a very good example because a law enforcement agency as defined by CRIA is rather narrowly defined as opposed to, let's say, a law enforcement agency as defined by Act 22, which governs police body cam, dash cam, and security cam footage. Believe it or not, under Act 22, and I'm not editorializing here, this is facts. Under Act 22, you could have a school district defined as a law enforcement agency. Okay, fair enough, that's the way the law is written. But then we come over to CRIA, and they define a law enforcement agency much more narrowly. Okay, and it's essentially any police department, a prison, district attorney, sheriff's office, or the courts. Okay, and you notice that school districts are not included in the definition. Or if we want to go back to Act 22, Amtrak or SEPTA are not defined as law enforcement agencies. Under CREA, it's much narrower, as I've been saying. So the purpose of CREA is to protect criminal history, investigatory, and intelligence information. Now, if I go over to the right to know law, I'm going to find criminal history and investigatory records covered by the exemption 708B16. But I won't find intelligence information. So consider this scenario. A police department maintains records of suspected gang activity within their jurisdiction. It's a collection of criminal intelligence information. Theoretically, under the right to know law, I would have access to that because it's not covered by the B16 exemption. But when I go to CREA, it clearly is there. So if someone were to submit a right to know request for that file on gang-related intelligence information in the jurisdiction, I would not be able to use 708B16 to withhold it, but I would be able to use CREA as my legal basis for denying access to that record. I would say this is not a public record because of the appropriate confidentiality provisions within CREA that do not allow me to release criminal intelligence information. Okay, so hopefully by using that scenario, you see how this all works. So in my denial letter, I would, deny access to it. I would say that what's being requested is criminal intelligence information, and then I would draw the nexus with CREA saying that under CREA, we cannot release criminal intelligence information. That can only be shared with other law enforcement agencies. Okay. Now, if you really need to do a deep dive into CREA, and honestly, if you're joining us from a law enforcement agency, you should, okay? This is one of those laws that if you're not already familiar with, you should be familiar with. Go over to the Pennsylvania Attorney General's website, and they have an excellent CREA handbook, which I've always considered as a great resource, okay? The link is on the screen right now. And you download it for free, and it's always something good to refer to. Also, they have excellent staff over there who, if you really have some concerns or questions or whatever, they're more than happy to help you out. They're a great resource for the law enforcement community. Okay, moving along, let's talk about another law enforcement. Okay, questions popped up. I am in a school and I just had a request come in asking how many employees have been charged with a crime and how many of those individuals are still employed. Okay, that's going to depend. Number one, do you even have that information? I'm just kind of thinking here. I think probably something like that is best referred to your solicitor. Because even though you may be charged with a crime, that doesn't necessarily means it ends up in the courts. Most, when a person is charged with a crime, it's probably best to go through the police department. But I see what someone is doing here. Oh boy, that's a really tough one, Dawn. And the thing is, given the circumstances, I don't know, because you may risk violating someone's privacy if they've been charged, but then the charges were dropped. We don't know that. So I would suggest punting that one to your solicitor because of the potential liability that a request like that has. Don't try to deal with this one yourself. The first question I would ask, do you even have those records available? Um, and yeah, are you even at liberty to release some of that information? I think probably that's something that your solicitor wants to do a closer look at. Okay. Would we respond with this as the denial? No, not necessarily, because if a person has been convicted of a crime, that is public information. But usually that's available through the courts, any convictions. So that's how you would get that information, not necessarily through the employer. Some employers just don't keep information like that on hand. So it's going to depend, like I said, whether or not you even have that information. Okay, that's a good question. I wish I could, give you a more definitive answer, but there's just too many, potential circumstances that I would be cautious of. Like I said, if someone were charged with a crime, but then the charges were dismissed for some reason, in some instances, records are expunged, and do they mean when the person was employed by you, or perhaps they, there were criminal charges prior to them being employed by the school district? We just don't know that. Okay, so I'm not gonna risk giving you too definitive an answer there, because there's just too many different circumstances that can muddy the waters here. Like I said, that's a good question for your solicitor, and I would take that right to know request to them and rely on their expertise there. Okay. Yeah, I think that's the best thing you could do. Okay, so let's talk about Act 30. Now, Act 30 deals with emergency call centers, 911. That usually occurs at the county level, where someone will submit a right to know request. I would like a copy of the recording of whoever called in, for this particular incident that the police responded to. Okay, well, under Act 30, well, first offhand, under the right to know law, 708B19 protects those recordings, and it's very tightly written. Okay, you usually can't get those recordings, but also under Act 30 of 2016, it applies to these 911 centers, and it basically says that they can't give out any individual identifying information of callers, witnesses, and victims. Now, when we talk about individual identifying information, it's the name, their phone number, and their home address, okay? They can't give out that information. Act 30 prohibits that from happening. Okay, but then you think about, well, what about the media when they're reporting on a police incident or a fire or something like that? Well, they usually don't give it out. Typically, they will give out the block number with a cross street, or if it's like out on the interstate, they'll give a mile marker. I'll give you a quick example. I'm working here today in the building. The address is 333 Market Street. But if there were let's say a fire in the building, the 911 center would dispatch the appropriate fire department, Harrisburg Fire Department, to this building address. But as far as giving any information out to the public, they would say it's in the 300 block of Market Street, or they would say it's at the intersection of 4th and Market Street, or, if it were out on an interstate, they'd give the appropriate mile marker, okay? But then you see in the media where they give out the actual address. Well, perhaps a reporter went to the scene and was able to see the actual address. Or, maybe it's the only building on the entire block, so they're able to, identify the building. This is typically known as, everybody knows it as 333 Market. It's the tallest building in Harrisburg. So, that's how the building is identified locally among the, most of the people who work in Harrisburg. But, it's also known as the education building by some. So you get this information because it's commonly known, and it's not unusual for the news media to be aware of, the fact that there's, fire apparatus out in front of 333 Market, and they report it as such. But if you were to contact the emergency 911 center, they could only tell you the block number, the cross street, or the mile marker, and they would not give out any individual identifying information of callers, witnesses, or victims because of their right to privacy per the Pennsylvania State Constitution. Okay, so Act 30 prohibits giving out that information. All right, let's switch gears here. And here's one that comes up fairly often these days, and it's attorney-client privilege and attorney work product. Most agencies, cities, boroughs, townships, school districts, authorities, and the like, rely on legal advice from a solicitor. And anytime you have an attorney discussing sensitive information with their client, typically the board or senior management, senior executives, that exchange of information is protected by attorney-client privilege. Okay, and that is based on law. Okay, it's a part of the rules of evidence in Pennsylvania, and that is founded in statute. Plus, within the right to know law, you'll find a reference to it in Section 305A2. All right. So, someone will submit a right to know request. I want to see all the emails regarding this particular topic exchanged between the solicitor and the school board. Well, very good chance that that exchange is covered by attorney-client privilege. And based on the fact that it's covered by statute, and statute deems that to be confidential, it cannot be released per the right to know law. It's considered, like I said, it's considered confidential. So then the question comes up, well, all I'm asking for are the invoices. I want to know how much our township is paying the solicitor, because I think this guy, is making too much money. I think we're wasting tax dollars with how much we pay our attorney. Well, that's neither here nor there as far as I'm concerned. But what about the invoices? And what it comes down to is how detailed are those invoices? If all the solicitors putting on, okay, for this month, I'm billing you 12 hours of my time for work that I did for the last 30 days, okay? Chances are that would be considered a public record. However, if the invoice goes into such detail that you can discern legal strategy, then that chances are very good that that would be covered by attorney-client privilege. For instance, let's say that I'm billing you 3 hours for my work on this particular lawsuit, where I researched case law based on a particular defense strategy that was used by another township that found itself in a similar suit. Okay, so based on that explanation, I can discern legal strategy, and it would probably be appropriate to invoke attorney-client privilege in that case. If you're in doubt as to whether attorney-client privilege should be applied or not, go to your attorney and ask them for their opinion. If, upon denial, the requester disagrees, they can file an appeal and fight it out before the Office of Open Records. And we, like I say, we deal with this on a fairly frequent basis. And per the Supreme Court of Pennsylvania, we are allowed to rule on whether or not attorney-client privilege applies. Okay, questions have come up. Walt, am I wrong, or was there recently something about invoices and how privilege doesn't apply to them, or was it the other way around? Well, Walt, I would have to look into I'd probably have to ask somebody about current cases, but I'm not familiar with anything recently. But, the standard that I just gave still applies, I would assume. Can you discern legal strategy given the detail of the invoices or not? If you can, chances are attorney-client privilege applies. If not, it's probably a public record. Does the solicitor have to say on the email or letter attorney-client privilege? No, they don't, okay? It's a matter of, like I said, the test would be, can you discern attorney-client privilege or attorney work product based on the detail provided? Invoices covered by attorney-client privilege, or should we just black out all details? Is that an option? Yes, that is an option. And what we're talking about are redactions. If you want to go ahead and release the invoice, but redact that sensitive information that would typically fall under attorney-client privilege, you can do that. But understand that the redaction in itself is considered a denial. So you could release the record thinking you're granting the request, but if the requester is not satisfied because of the redaction, they can appeal it, okay? And you'll just, you come before an appeals officer, you don't come, but you present your case before an appeals officer and they'll make the appropriate determination. But yeah, that's a very good question. You can redact if you think that's appropriate. What if you redacted the case information and just, that's same question, Sherry. Okay, you can do that. Okay, so good questions, keep them coming. Let's move on. And let me get a sip of coffee so that we can talk about the Uniform Construction Code. This is the building code for the state of Pennsylvania. And it applies to any agency that possesses building permit applications, plans, or associated records. Okay, and under the UCC, it protects applications, building plans, specifications, inspection reports, and similar documents. Okay, that phrase can be problematic sometimes for buildings constructed after 2004. Okay, why 2004? Because that's when the UCC became effective and the confidentiality provisions were not grandfathered. Prior to 2004, there was somewhat of a mishmash, that's a very technical term there, of building codes across Pennsylvania. And, I was around in 2004 and I remember all this. Depending, let's say you were a developer or a contractor. Prior to 2004, you would need to be familiar with every different building code that any local municipality could have had adopted. There was the Life Safety Code, there was the BOCA Code. There were local, specifically local codes that they customized for their specific municipality. It was all over the place. So it was, it was really hard for a developer or a contractor because you could be, have a standard building practice that would be within code in one municipality and out of code in another. So 2004 came around, the legislature wisely adopted the Uniform Construction Code. Okay, so what if someone requests information for a building prior to 2004? Well, if you still have those records, you would have to go back and take a look at any, if they even had them, confidentiality provisions within the specific code that was in force. Session is being recorded. Yes, it is, Judith P. I covered that during the opening comments. Okay, and it will be scheduled later again this year, I promise. All right, you would need to know what building code was in force and take a look at whether or not that building code had any of the appropriate provisions for confidentiality. Now, building permits themselves are public records. It's just that most of the other records that led up to the issuance of the approved building permit are not, okay? They're considered confidential based on this privacy provision in UCC. Now, here is something that a lot of people are not aware of, and it's falls under the definition of case law. If you read the UCC, your first impression are that it only applies to commercial construction. And for the most part, that is accurate. But in 2012, our office ruled that the privacy language within the UCC also applies to residential structures. Okay, so you're thinking, and this has happened. Right to know request is received. I would like the building plans for this particular residential structure. All right. Now, my first impression is, why would we ever give out someone's plans for their home? But if we take a cursory look at UCC, we're thinking, well, that's not going to help because it only applies to commercial structures. But if you read our decision, Ness versus York Township, it's not necessarily what the UCC says about privacy, it's what it doesn't say. All throughout the UCC, you'll see the specific term commercial used with the buildings that it refers to. When you get to the privacy provisions, it changes. Actually, the word commercial disappears, and it just refers to buildings in general, structures or whatever. So our logic, and this has never been successfully challenged, is that because of the removal of that word, all structures, commercial and residential, are now covered by the UCC confidentiality provisions. Okay, and this stands. Our decisions carry the weight of law. So this gives agencies the legal authority to deny access to home plans if they're submitted through the building permit process. Okay, and again, it goes back to common sense. Why would you give out anybody's home plans? Okay, now the question has come up, what about stormwater management plans and actual building plans of a house? Okay, well, the building plan I just discussed. Stormwater management plans, I think that's going to depend on, number one, will you find that reference in the UCC? I'm not familiar enough, Sherry, with the UCC to tell you whether or not stormwater management plans would be covered by it. Number two, stormwater management plans typically involve the right-of-way, which would not be covered by UCC and would probably be covered by township plans. But don't take that, as law. Again, I would first look at the UCC and determine whether or not what we're asking for with approval is on the private property or public land, because that would make a difference. All right, so someone takes over property and the plan was not theirs to begin with, but now they own the property. Okay, that's a great question, and I have the answer for it. Within UCC, while they make these plans private, there's also a reference that the agency can release them based on a need-to-know basis. So to answer your question, what if it's the property owner? Someone buys a new property, can they get all the documentation that led to the approval of changes to the property over the years? The answer is yes. You can release it to the property owner. You can release it to an agent of the property owner. You can release it to a contractor who has the property owner's permission so that the contractor is aware of what improvements, what am I getting into when I start putting holes in the wall or tearing down a ceiling or something like that. Okay, they can have it. It's a very good question, and I'm glad I was able to answer that for you. Okay, now any citations as the result of violations of the building code, that if it escalates to the level of court action, that becomes a court record, okay, which the agency probably wouldn't have. The township or borough wouldn't have that information, but the courts would. So if I want to know what happened as the result of a violation of the building code, I would go to the courts, not necessarily to the agency. All right, and then if it's a zoning issue, That's not covered by UCC. That's covered by the municipality's planning code, which is an entirely different law in Pennsylvania. And we don't see a lot of action with zoning issues. Okay, let's switch gears entirely, and we're going to go into healthcare related laws now. First one is probably the one you're most familiar with, HIPAA, the Health Insurance Portability and Accountability Act of 1996. This applies to healthcare providers, not typically employers. Okay, we issue zoning permits, not building permits. Would that be released? Again, zoning permit is something different, Sherry, and you would want to take a look at the Municipalities Zoning Act on that. I'm not intimately familiar with that, so I can't really address your question. But good question for the process nevertheless. Okay, so HIPAA applies to healthcare providers, but occasionally you will find a municipality that has a relationship, an organizational relationship with some sort of, like a senior center. It used to be that, counties ran what used to be called the county home, okay? Well, typically over the years, that's been contracted out, but through that contractual relationship, there may still be a relationship with the legal jurisdiction. Okay, so you may have a kind of, in a roundabout way, the jurisdiction being considered a healthcare provider. Okay, so any health-related information that they may have access to would be protected by HIPAA. Okay, and HIPAA makes it very clear. This is not public information. You do not give out any health-related information. Okay, now, in some instances, you may run into a situation where you've got an employee who approves the voluntary release of their health information, usually to the employer, okay? Because the employer now has access to that information, they have a legal obligation to keep it secure, okay? And there are other laws that cover this more clearly, but you need to be aware that HIPAA is out there, and HIPAA basically says you do not give out any individually identifiable health information, okay? You just don't do it. It's protected. And the agency could be, well, the person giving it out could be subject to liability if they were to do so, okay? It's pretty much black and white. You don't give out this kind of information. Okay, another law that agencies would more typically run across is the Family Medical Leave Act, or FMLA, as it's more commonly known. Okay, in a previous career, I was the Human Resources Director for a large state agency. And I remember when FMLA came out. Prior to that, all of our health-related information on an employee went into their personnel file. And at that point, it was, a hard copy paper personnel folder. Went in a file cabinet, the cabinet was locked along with all their other information. When FMLA came out, we had to pull out any health-related information, and that went into a separate file. And only our benefits staff had access to it. Even I, as the HR director, couldn't access it, okay? And FMLA, from my perspective, it dealt with two main things. Any accommodations needed for employees with a serious health condition and the leave related to specific sets of circumstances, whether it be paternity leave or maternity leave was more common, and serious health conditions, okay, if I had to take time off. So from an agency perspective, you really need to be careful about what, if any, employee leave related records you might release, okay? For instance, let's say that you've got an employee who takes a couple days off and they take them off as sick days. Well, if you're familiar with FMLA, I think it's FMLA. Let me advance the slide here real quick. Yeah, it's FMLA. It's been a while since I've done this presentation, but under FMLA, if you take 3 days off sick, by rights, the HR department should send a survey to the employee. Is this absence related to a serious health condition? If the employee indicates that it is, then in addition to being charged sick, the HR department will deduct those 3 days from your FMLA leave balance. Okay, and I don't want to get into the weeds here, but that's how that works. But here's the thing, a serious health condition and whether or not an employee suffers from that, I hope that's an appropriate term to use, suffer from a serious health condition, that's confidential. You do not release that to anybody outside of the benefits administration of the agency. So if someone, let's say someone takes a couple days off and let's say they're out mowing their grass. You know, they didn't take sick leave, they took vacation leave and they're out mowing their grass and they've got a nosy neighbor. You know, what do they do at home? So they submit a right to know request to the agency asking to see the leave records for this employee. And you're thinking, whoa, now this is a little over the top. I can tell you firsthand though, this has happened, okay, more than once. So the agency, they're thinking, well, can we release the leave records that show this employee was on vacation? Technically they can, but if there's any way by putting 2 and 2 together, I see 3 consecutive sick days. This employee has a serious health condition. Uh-oh, the agency just violated FMLA. And again, they could be subject to sanctions for doing so. So you need to be very careful about what, if any, leave information you release about your employees. I would err on the side of caution and not release it, but that's up to the agency to decide, as long as you're very careful not to disclose the fact that you may have an employee who is experiencing a serious health condition. Okay, and then another law, again, health related, is the Americans with Disabilities Act. Now this applies to most employers. You can get to, down, I think it's below 20 employees, but still government agencies, may still fall under this. But it protects all medical records and requires that they are stored separately. Like I said, same way with FMLA, than from other personnel related records. Okay, so they're kept separate. And then here's one that you need to be aware of. Any information, any health related information provided voluntarily by the employee as the result of a non-medical inquiry are not covered. Okay. Now let me give you an example as to how this provision applies. We've got our staff, they're all in a particular building. It's multi-story, okay, 3-story building that the township has. Or let's say it's an old borough hall, okay? And we've got an employee who we've assigned as the fire marshal, okay? If there's a fire in the building, they're in charge, and they've got deputy fire marshals that oversee each floor. Chances are you work in this sort of environment. So they send out a survey. The fire marshal sends out a survey to all the staff in Borough Hall. If we have an emergency, is there anything special we need to know about so that we can help you evacuate the building? Okay, so one employee, based on this non-medical inquiry, writes, yes, I've had a hip replacement and I have difficulty walking downstairs. So I'm going to need some help. Okay, the hip replacement is a medical condition that has now been disclosed to the fire marshal as the result of a non-medical inquiry. So they would let the deputy fire marshals know if George, if we have a fire, George needs help. So they would take me to the stairwell and stage me there. And then when the fire department shows up, the fire marshal would report that we have an employee with mobility problems. He's been staged on the 3rd floor of the stairwell. Okay, you're going to have to evacuate him. All right, so that way, the information is kept confidential, but only released by the fire marshal on a need-to-know basis. Okay, but that's how other people would become aware of this person's, or, in this instance, mine. And I haven't had a hip replacement, but one of these days. They would become aware of someone's health condition. Okay, so you see how that all works. This would not be a violation of ADA and how that all transpires. All right, questions come up. We use PTO, but pay stubs state how much was taken. Are pay stubs a public record? Not necessarily, Judith. What we pay a public employee is considered public information. But if by releasing the pay stub, that may also contain leave-related information, you would risk divulging whether an employee has a serious health condition, then I would say either you withhold the pay stub or redact that leave information when you release the pay stub. And, this raises another issue. If there is any pre-tax pay withheld at the employee's discretion, that is also private. So let's say I have money taken out of my pay as a donation, as a tax-free donation to a particular organization, that could be withheld because that money is then not provided. Yeah, a pre-tax health deduction. Oh, okay, I see what you're saying. Yeah, I would withhold that. Because that is at the employee's discretion, not the employer discretion. Okay, so I would take that out. Okay, yeah, glad we made sense of that. Okay, good one. Moving on, okay. Switching gears, here's one that comes up fairly often. This applies to school districts and by extension, charter schools. And it's called the Family Educational Rights and Privacy Act, okay? They call it FERPA, okay, common acronym. Okay, it applies to public, private schools, primary, secondary, and post-secondary, meaning colleges and, gosh, what's the word escaping me? Trade schools, okay? So it protects any individual educational records, anything that refers to the student directly. So it could be a report card, transcript, any record of discipline. Okay, then you're saying, well, what about sports information, like the fact that the football team, was on a win streak, and at last night's game, this student, scored 3 touchdowns, or had 2 interceptions, or 3 sacks, or whatever. Okay, that's isn't that an educational record? Well, by rights it is, but FERPA allows for what's called directory information, which is this general kind of public interest sort of information that can be released, or the fact that these students made the honor roll this quarter. Okay, so that is public. Any aggregated data as far as how students are doing education-wise is also considered public. So there are, probably dozens of reports that a school district has to file throughout the academic calendar to the Pennsylvania Department of Education, to the Federal Department of Education, and the like, that are aggregate in their makeup. Well, those typically are considered public. Unless, and this has come up, if the report is of such detail that you can slice and dice it to the point where you can identify a specific student, then you can withhold that aggregated data. For instance, we had a case where, based on the nature of the report and how it reported test scores by ethnicity, you could identify that a certain, in this case, the student was considered a Pacific Islander. I think that was the category used. Well, within the grade, there was only one student who was their ethnic heritage was Pacific Islander. So the superintendent was very concerned about releasing this report. And ultimately, the Office of Open Records agreed that they had to go up a couple levels so that, it was more aggregate in its nature. And I think they were able to arrive at a suitable accommodation for the requester based on that. But, as a general rule of thumb, aggregated data is considered public. Now, what about the parent that is concerned about test scores for their child, or who they are the guardian of? This will come up periodically. Within FERPA, there is a provision that allows, there is an avenue for parents to see the grade information for their own student. Okay. Unfortunately, what we experience through the right to know process is the school district doesn't explain that to the parent when they issue a denial of a right to know request. So the parent ends up appealing, and at some point it's explained to the parent after a lot of heartache, a lot of headache, and more work than what should have occurred. So if you're here from a school district, my request to you is that, look, we understand the constraints that FERPA places upon you, but when you deny a right to know request for individual educational records of a parent based on the provisions of FERPA, you should also, make a phone call or perhaps put it in your denial letter that, oh, by the way, you can get these records. You just need to file the appropriate request through the FERPA process. Okay, and you would be saving everybody a lot of work by doing so. So, just a little editorializing there. And then, what if we're dealing with a college and a student gets themselves into trouble with the law, and it's the campus police force, which has full Act 120 powers? Those records, if the student is 18 or older, are considered public. Okay, they're considered police records. And if charges have been filed, kind of like what was intimated earlier, it's possible that a record of those charges would be considered a public record. Okay, and then we get into the whole bit with school videos. This is an emerging area of the right to know law in Act 22. And so forth and so on. And it's like the basic question, are videos taken by a school district public or not? What I can tell you is that it depends, okay? It depends on quite a few factors. You're going to have to do some research into current case law. And you can go into the case law index on our website and kind of get an idea. Where we're at now, the latest court decisions are dealing with releasing the videos, but you use software to blur out the faces of students. And again, that depends on the situation. I just can't give you a black and white answer at this point. I think ultimately we'll have kind of a body of case law that will be able to provide some guidance on, but until that case law evolves, we're kind of in a gray area right now. And you're just going to have to, either take a shot at an appeal or have your solicitor do some research on current case law when it comes to school videos and whether or not you can have access to those. And then, of course, any health-related records kept by the school district would be off the table based on the language in FERPA. Okay, the Pennsylvania School Code, this is kind of an extension of FERPA. It's out there. If anything, it provides a little more language for protecting any educational records. And it also clearly identifies any health-related records that are kept on hand, like, by a nurse or a nurse's assistant, who needs to, for instance, administer medicine to a student at lunchtime or, some point during the day. All that information is considered confidential. Okay, you cannot get that through the right to know process based on this language in the Pennsylvania Public School Code. Another sip of coffee here. Pennsylvania Motor Vehicle Code. Okay, what if I submit a right to know request to the township because I saw one of its employees driving a piece of equipment the other day? I don't think they have the appropriate license. Well, under the Pennsylvania Motor Vehicle Code, any license is considered an individual's driving record, and those records are considered confidential under Section 6114 of the Pennsylvania Motor Vehicle Code. Okay, that would include like a CDL. Okay, if I have a CDL that authorizes me to use a specific piece of equipment because of its gross vehicle weight or the nature of that piece of equipment, you would not be able to get access to any of my driver's license information. Now, what if I have a problem with speed limits, or I've got a problem with red lights or whatever? Okay, if any criminal sanctions are taken against me, then that becomes, again, a court record, and those records are accessible through the court system. The Section 509 provisions, 509 or 409. I think it's 509. If I want to get a record from the court, they have what's called the 509 system. So I would go through the courts to get my driving records, provided I have moving violations. Okay, but as far as any information related to my license or the acquisition of that license, you would not be able to get it through the right to know process based on language in the Motor Vehicle Code. Haven't seen that one in a while, but it has come up. I remember fielding some phone calls over that. Okay, interesting one, the federal copyright law. This one comes up more often than you would think, but it applies to anyone claiming or using intellectual property in the form of authorship. Okay, what does that mean? Let's break this down to a real life set of circumstances. The agency relies on the work of an engineer or architects to provide design information on things that are going on in the township or borough or city or whatever. And they include blueprints, okay, drawings of what they intend to do or what they intend the contractors to do. Okay, so usually on a drawing, there's at least one stamp. And this is where sometimes agencies mess up. That stamp, all that usually says is that I've prepared this drawing and I am a licensed architect, or I am a licensed engineer, licensed engineer. We're in the United States now. Licensed engineer. So I am qualified to provide this drawing. And that's it, okay? It doesn't infer any sort of original thought, thus there's no claim to privacy. However, occasionally you will see a second stamp where the engineer or architect is claiming original thought. Usually you will see this more with an architect's drawings than an engineer. But they're saying, these drawings that I am submitting are are so original, so unique, that I don't want to risk anybody stealing my ideas. Okay, so I'm claiming copyright. An engineer, you typically would not see or any claim of copyright, because an engineer usually should be following standard, what I want to call standard industry practices. And if they deviate from that, well, they might be facing some potential liability issues. So, there's only one way, or one group of ways in order to facilitate stormwater runoff. And, given X, Y, and Z, you use this type of drainage system for this particular application, okay, because that's the industry standard. So you don't see a lot of copyright claims with engineers. But, if you do, maybe you've got some other issues that you should be addressing. But, I don't want to get off track here. Okay, so questions come up. Would it apply to any literary or artistic work under the Berne Convention? Okay, I'm not familiar with the Berne Convention, but it is possible that you could claim copyright based on some literary submission. It's hard to think of how that would apply to a government agency, but it's possible. Okay, it is possible someone could claim copyright. And it would apply under the right to know law, which is why we're here. Okay, so let's discuss this further. So let's say the agency is in possession of a record where copyright has been claimed. Someone submits a right to know request to see that record. Under the right to know law, you have two avenues. I can request a copy of the record, or I can request to inspect the record, which is where I can come in and view the original, provided it's been determined to be a public record. Okay, so under this court case, Ali versus the Philadelphia Housing Finance Authority, the Pennsylvania, I believe this is the Supreme Court. I believe the Pennsylvania Supreme Court ruled, no, it's the Commonwealth Court. The Commonwealth Court ruled that you can inspect the copyrighted record, but you cannot have a copy of it. Okay, and that's how the right to know law would apply. Now, if there's any dispute arising over whether or not this record should be copyrighted or not, that's not the agency's problem. Under the federal provisions, any dispute is between the person claiming copyright and the person allegedly misusing the record. And simply taking a picture of a copyrighted record is not misuse of it. But that's not to say you should allow them to take the picture, okay? It's just that if they do, when your back is turned, you're not breaking the law, okay? And the person taking the picture isn't necessarily breaking the law. It's what they do with that picture that could lead to the potential copyright violation. Okay, but again, I don't want to get into the weeds here. Essentially, what the court says is that under the right to know law, you can inspect the record, you cannot have a copy of the copyrighted record. Okay, I've got a couple of questions popping up here. We get RFP bids, vendors claim the information is confidential. Would we have to redact that information and tell? Okay, it's up to the agency to determine whether or not it truly is confidential. And when it comes to bids, there may in fact be bona fide confidential information in there. You want to take a look at the provisions of the appropriate law that govern how you handle bid information. Under the right to know law, most of that information is considered confidential until the contract is let, and then the information provided by the successful bidder becomes public. But even then, if they're claiming that there's confidential information within that bid package, it may in fact be confidential. But again, there are other laws as well that govern bid information. You want to familiarize yourselves with that as well as what the right to know law says. If the government paid public dollars for a concept, how can it be copyrighted? I don't think it can be, Judith, because the architect or engineer or whomever can't claim it as original thought if the government agency, in fact, owns the work of that particular contractor or employee. For instance, when I worked full-time for the state of Pennsylvania, any of my work product, like if I came up with a novel solution for resolving right to know requests or appeals, the state of Pennsylvania owned that solution. And even though it was my original thought, basically they own that original thought, and I can't. Even to this day, now that I no longer work for the Commonwealth of Pennsylvania, I can't claim it as my own property because I came up with that idea when I was being paid by the Commonwealth of Pennsylvania. So yeah, it's a very good point. I don't want to get into the weeds here with copyright, but it's a good one. Mostly they claim pricing is confidential. Yeah, that's with the bidding information, how they arrive, and sometimes this is, they need to put this information in their bids in order to explain how they arrive at their pricing schedule. That is confidential. And it's called, a better word than confidential is proprietary. Okay, and there is a provision within the right to know law that allows an agency and bidders to withhold proprietary information. And I think that's what we're talking about here. Trade secrets, okay, another category of proprietary information, which can be withheld under certain circumstances. Don't consider that a blanket statement. And again, it's something where you want to get into the case law. But that's what you're talking about here, proprietary information. And there are, a host of decisions that deal with whether or not proprietary information should or can be withheld. Okay, let's get out of here because we're coming close to the end here and we're running over, but I'm not sure what over is these days. Child Protective Services law, this involves kids, okay? And it applies to anyone in the course of their employment who comes into contact with children. Okay, you're thinking, well, agencies, come on. Well, what if your township has a summer parks program and you've got activities for kids? This goes way, way back, but when I was a kid, you could go over to the school across the street from us, and there was a summer parks program that the school district put on. Well, nowadays, if they were still doing that, this would give them access. School-funded employees who had regular contact with children. Okay, so here's the scenario. What if your township has one of those programs and one of the employees, or for that matter, what if it's a volunteer, but still they've been vetted by the agency, and they see some injuries on a kid that leads them to suspect some form of child abuse? Well, legally, they must report that suspected child abuse. Okay, so any documentation of them reporting that and the subsequent investigation is considered confidential. Okay, you do not give that out per the Child Protective Services law. All right, so we escalate this a little bit. What if there's a divorce taking place and there are claims by one parent against the other or whatever, and the agency is put in the middle. Okay. One parent says, I suspect that the abuse is coming from the other parent. Okay. But the claim of, or the report was made by one of your volunteers. So now you're getting right to know requests to the agency to see these evaluations and so forth of the suspected child abuse because you're caught in the middle of divorce claims. Well, as hard as it is, you've got to remove yourself from all this, and the Child Protective Services law prevails, okay? Do not find yourself feeling sorry for a parent because they've been shut out of the process due to what you think might be spurious claims. There are other ways for that parent to get the information that they need. They just need to go see an attorney, okay, and let the process work itself out. Okay, do not release any of this information or you could find yourselves in hot water. Okay, I know it's hard. We've kind of found ourselves in the middle of this here at the office every so often. You've just got to follow what the law says. Okay, and then with your volunteers and with your employees, you've got the child line clearances, okay? And all of that, the application process is considered confidential, where they do, you know, the criminal history check and the like. You can tell the public that all of your volunteers have cleared through the process, all of your employees that have regular contact with children, they are cleared through Childline, and you know, we are in compliance, but you don't have to show them any of the documentation other than the approved clearance itself. Okay, nothing like that needs to come to light as a public record. Okay, and then the final, well, the final law that we need to talk about is the Older Adults Protective Services Act. You don't come across this very often, but recently we did. This applies to elder care, senior centers, and it only applies to employees of those senior centers. And it's adults over 60 who can't take care of themselves. So if an employee of an elder center, like you know, area office of aging center, suspects that someone is being abused, they have a legal obligation to report it. And again, it goes back to any of the information, any of the documentation related to the report and the investigation are considered confidential. You will occasionally get into this. Well, I think we're seeing it more and more, actually, where you've got adult children where, you know, maybe there is some suspicion that a caregiver is abusing, or, you know, that maybe one of the adult siblings is abusing, or it could be a spouse, you know, abusing. But that information under the Adult Protective Services Act is considered confidential. It is not given out. So you may run into records of this at the county level, certainly at the state level, and potentially with local level governments. All right. Oh, the Disease Prevention and Control Act. I forgot about this. This came up during COVID, okay? We haven't, I may be removing this soon, but I think all the case law has pretty much run its course on this, where you cannot give out like individual instances of COVID infections, okay? But the news media and the like were asking, well, what about aggregated data? You know, what about, you know, how many infections were there within this particular population area or whatever? And these reports were available, but the Department of Health and county health agencies were withholding aggregated COVID infection data based on language that they felt within the Disease Prevention and Control Act of 1955 gave them the legal right to withhold. it came to the Office of Open Records. We said, no, that's not going to work. It got appealed to the courts. The courts agreed, said, no, you give out aggregated data. I think it's pretty much run its course. It's not, there's no information being given out, or I'm sorry, the courts have said that aggregated data now is public, and we haven't, there haven't been any mass outbreaks in recent history. It's just not an issue. But, like I said, I'll probably be taking it out because we just haven't seen any activity on this in at least a year. But it's out there, okay? And the legislature has talked about revising the law. I don't know if they've gotten around to doing that or not. I'd have to do a little bit of legal research there as to whether this law even exists as it did. Okay. Then some miscellaneous stuff that you should be aware of. W-2s. Yeah, every so often you see a request for a W-2 or W-2s for public employees. Under the Internal Revenue Code, W-2s are considered confidential. You do not give out W-2s. It's kind of like the earlier question. You can give out a payroll statement provided it doesn't include any confidential information, like maybe the employee's home address. Okay, that's considered confidential, which I'll talk about here at the end. But W-2s in and of themselves, you don't give them out. In Pennsylvania, we have the Taxpayer Bill of Rights, which makes it a misdemeanor to release any confidential tax information, whether it be about public employees or the public in general. You just don't give out tax information. There's also the Local Tax Enabling Act, which is the acronym LT. You'll occasionally hear that reference. Under LT, it protects any information that can be obtained through a tax investigation or the submission of tax returns at the local level. Okay, you, just as a general rule, you don't give out tax information for residential stuff. Occasionally, you can give out when a business is arrears in its tax payments to a municipality. And there's case law on that. I'm thinking this goes back quite a few years, but for instance, I think it was the borough of Lemoyne. They were withholding in Lemoyne in Cumberland County. They were withholding business taxes and arrears. I think it was for the Water and Sewer Authority, but it was the Harrisburg Patriot News versus Borough Lemoyne, and we ruled that those are public records, and the court upheld our decision. Okay, then we get to home addresses and dates of birth. Okay, under a case law with the Pennsylvania Commonwealth Court, and it extended to the Pennsylvania Supreme Court, where what about home addresses? And anyway, it started with home addresses and it extended to further information, where the Pennsylvania Supreme Court relies on a clause within the Pennsylvania State Constitution that they call the constitutional right to privacy. And we have used that, we've extended that to any information regarding an individual where within the right to know law, you can withhold home addresses and dates of birth for an individual. Now, when we talk about dates of birth, the month and the year are public, but the date itself is private, okay? And that should, at this point, should help with any potential identity theft, okay? It may change. I'm not aware of anything in the wind right now, but the date of birth and home addresses are clearly deemed confidential by the Pennsylvania Supreme Court for the constitutional, for any person. Okay, question, what about employee salary? Okay, public employee salary it's clearly public information. What I make as a public employee or, as an annuitant for the Commonwealth, and when I worked full-time for the Commonwealth, clearly was public and should be released, okay? I'll just say, taxpayers have a right to know how much public employees are being paid. I'll just look at it from that perspective. Okay, can I explain the Taxpayer Bill of Rights again and what the confidential information is? Yeah, under the Taxpayer Bill of Rights, any confidential tax information, for instance, what I pay in taxes to my municipality a year is considered confidential. Now, my property taxes, that relates to the property itself, and typically that is public. I mean, gosh, you can go out and find that on Zillow nowadays. But any other taxes that I pay would be considered like if I get dinged for an improvement to my property before it becomes public information, that might be considered confidential. Gail, I think it's best to say it's probably on a case-by-case basis, but in general, you want to be very careful about any tax information that's released. Donna, our phone numbers, personal phone numbers are considered confidential. Work phone numbers, there's case law on that as well. Okay, now listen up. If my work phone number is held up to the public, like if you can find a directory online, like on our website, then it's considered a public record. But if typically, like say the phone on my desk, we don't give out that phone number on a website or business cards or anything like that, I can claim that that is not a public record. And there's case law to support that. I think that goes back to, it dealt with the Pennsylvania State System of Higher Education. I can't remember the specific citation, but I think that's the agency where it was deemed that if the phone number on the desk phone is not held up to the public, it's considered private. But like the phone number for the office, clearly that would be a public record. But also clearly private phone numbers, you do not give those out. Okay, PennWatch, you're referring to a website that's maintained by the state of Pennsylvania where they list the salaries for every state employee. They do not put the salaries for any local government employees. That would be up to the local government to do that, or school district or whatever. Is the statement of financial interest confidential? It is not, okay? I believe you can go to the State Ethics Commission, search their website, and find the statement of financial interest for most public officials, whether it's state and local, and all state employees. And while that does not necessarily list the salary, it does list where they get their financial payments from. I know you could look up mine and find it there. Okay, and if the local government is in possession of the statement of financial interest, it's a public record. Okay, bottom line, to answer your question, is the statement of financial interest confidential? The answer is no. And for those of you who may not be familiar, every public official, every state employee, not every state employee, but those qualifying, those who have worked with contracts and so forth, must file annually a statement of financial interest. And, as an annuitant, as a consultant, I just did this last week, I think it was, where now the State Ethics Commission has that on file and is considered a public record. Okay, if the company pays a portion of the sale, is the number a public record? Okay, I'm not sure what you mean by company. But the bottom line is, if the number is held up to the public in any way, it is a public record, that the phone number is a public record. If it is kept private by the public agency, it is not a public record. That's the general rule. Okay, If a police report is being given out, should the addresses of individuals involved be redacted? Probably it should be, okay? I would recommend that you redact the home addresses as a general rule. I'm just thinking out loud here. Actually, just thinking. Yeah, I would rule on, I would err on the side of caution here and redact home addresses, because it kind of goes back to Act 20 that we were talking about back close to the beginning, or Act 30, where the 911 center cannot give out the home addresses. So I would think law enforcement agencies in general would not give out a home address, just as a general rule. I would be very cautious about what addresses I give out. Okay. Yeah, other questions coming in. That's okay. I'm here to answer your questions. Okay, financial interest forms show creditors to whom money is owed more than 65. This is allowed public knowledge. Yes, it is. It used to be the fact that I had a mortgage with the Pennsylvania State Employees Credit Union. Okay, that was listed on my statement of financial interest, along with the interest rate, if I remember correctly. Okay, so yeah, it's part of the public record. The reasoning being that as public officials, we have an obligation to show transparency, that any obligations, that there would not be a conflict of interest. For instance, what if there was a bank in the township that wanted to expand its parking lot? So they had to apply for a permit with the township. But as a township supervisor, I had a mortgage with that bank. Okay, well, that's a potential conflict of interest. So that needs to be reported on the financial interest forms. And the public has a right to know of that potential conflict of interest. Okay, so you see the logic there as to why, if you're wrestling with this, why would I ever, release this information to the public? There's a very concrete example that shows why you should. Okay, it's just part of being a public official or a high-level public employee, as to, this is what we're buying into when we run for office or when we take those jobs. Okay, accident reports, the addresses are there, so I wasn't sure. Yeah, again, accident reports are interesting because accident reports are not, they're not accessible under the right to know law per se. They're accessible under the Pennsylvania Motor Vehicle Code. So if the addresses are included there, all we're saying, this applies to the right to know law, not necessarily other laws where this information is released. The case law that I referred to, for instance, the Campbell versus Office of Open Records case, where there is the discussion of the constitutional right to privacy, that deals only with the right to know law. It does not cover the Motor Vehicle Code. It doesn't cover, the Pennsylvania Crime Code, which may have different language about releasing addresses. Okay, but you need to know what those laws say and how they relate to confidential information. Still, so yeah, good points raised by all. I appreciate it. It's been a good discussion. Okay, any other questions before we close out the session and I log off? Really good participation today. Thank you all for your questions, and hopefully we were able to give you a lot of good information. We will be back in 2 weeks with another session. I forget whether it's one of the basic sessions. I forget whether it's Sunshine Act or I think Right to Know Law. But yeah, well, thank you all for your kind comments, and we'll see you again in 2 weeks with our next webinar. Take care, folks. Enjoy this nice warm weather that we're getting, and we'll see you soon.